Sweet, sweet justice. Remember Cindy Pryor, who sought $250,000 in damages from students at Queensland University of Technology for objecting to segregation on the QUT campus? Well, now the worm has well and truly turned. So as you may recall, Cindy Pryor took a group of Queensland University of Technology students to court under the notoriously exploitable Section 18C of the Racial Discrimination Act. And what for? Well, the crime of pointing out the hypocrisy of the university's practice of segregating Indigenous students by having Indigenous-only computer labs. Click the link above to my previous video for more details. So a month ago, the District Court dismissed all charges and the case was thrown out. And yesterday, the tables were turned on Ms. Pryor as she was ordered to pay the students somewhere in the order of $200,000. Quote, Section 18C complainant Cindy Pryor faces being pursued into bankruptcy after a judge ordered she pay an estimated $200,000 in legal costs for 3 QUT students who were accused of racial hatred over Facebook posts. Ms. Pryor, on stress leave since late May 2013 from the Queensland University of Technology's Indigenous-only Ooguroo unit, was in talks with her solicitor, Susan Moriarty, after Judge Michael Jarrett made his finding in the Federal Circuit Court in Brisbane late yesterday. Well, it looks like she might actually have a legitimate reason to feel stressed this time. Judge Jarrett rejected arguments by Ms. Pryor's barrister Susan Anderson, including that the ill-fated and controversial legal action to win $250,000 compensation from the students should be treated differently because it was brought in the public interest. The judge, who last month dismissed Ms. Pryor's Section 18C Racial Discrimination Act case against the students as having no reasonable prospects of success, made a distinction between public interest litigation and the personal financial benefit she sought as compensation. Well, exactly. The idea that this was purely a public interest case when she sought $250,000 in damages is facile. If Ms. Pryor cannot pay the costs, she will be bankrupted, and if she recovers any money from QUT, the trustee in bankruptcy will be asked to make a claim on those funds to pay her legal cost, he said. Ms. Pryor is continuing an action for $250,000 damages against QUT over the way it handled the Facebook saga. So I have a feeling that QUT will probably end up on the hook for this misadventure, and they do bear some responsibility. But Pryor is the one that should bear the brunt of it. She used this easily exploitable section of the law to grievance monger, and it has backfired spectacularly. While Ms. Pryor faces financial ruin unless she can raise the money, her solicitor was spared the rare ignominy of being ordered to pay costs personally. Judge Jarrett said as the case was not completely hopeless, he rejected a bid by Mr. Wood's barrister, Michael Henry, to have costs awarded against Ms. Moriarty. Well, that's lucky for Moriarty, but if she isn't guilty of being an ambulance-chasing grievance monger, she's definitely incompetent. You see, after the initial ruling to throw the case out in November, she had 2 weeks to appeal the decision, but she failed to meet that deadline and then blamed the judge for not telling her about it, despite the fact that it isn't the judge's role to do so. But the real tragedy in all this is that none of it should have ever happened. It should never have gotten past the Human Rights Commission in the first place. The process of mediation by the Commission was bungled, the students were dragged through a costly court battle for 3 years, and the only people that will end up with any money in their pockets are the lawyers. The head of the Human Rights Commission that presided over this mess, Gillian Triggs, has a lot to answer for, but she won't be held accountable and will continue to collect her $400,000 a year taxpayer-funded salary until her term is up next year. And thankfully, she won't be getting another one. But if nothing else, this whole debacle should be held up as Exhibit A in the case for repealing Section 18C and abolishing the Human Rights Commission altogether.